Hi, I'm Joel Beck of the Beck Law Firm LLC in Lawrenceville, Georgia. When we work with clients to make sure that they've protected their family, one of the issues that some clients struggle with is who to name in their will as their executor, as the guardian of any minor-aged children, and as the trustee to manage assets left behind to care for those children. Today I'm going to share some thoughts on this important subject. So when we think about naming someone to be an executor of a will, you need to understand first what the role is. The person who serves as executor is going to be responsible for gathering your assets together, for paying your bills and expenses, and then distributing those assets in accordance with your will, subject to oversight of the probate court. Now, some people believe that this role should always be filled by the oldest child, if he or she is an adult. Well, that person might be a good choice to be executor, but he or she might also be a terrible choice to be executor. Understand that as individuals, we all have our own strengths and weaknesses, and we have different types of skills and abilities. Certainly, there's probably one or two things that I could do better than you, but on the flip side, there's going to be some things that you can do better than me as well. And when we look to choose people to serve in these fiduciary roles in our estate plan, we need to keep that in mind. We need to make sure that the people we are selecting for these roles have a good mix of skills and ability, as well as capacity to be able to carry out these jobs and the tasks that are associated with it. Now, a key point in choosing an executor is finding someone who's organized, who's capable of fulfilling the role, and of course, someone you trust to do a good job and carry out your wishes. Now, that person might be a relative, it might be a friend, or you may decide you want an impartial and independent third party, such as a bank trust department or another professional, to serve as your executor. You may also think that the executor needs to be local, needs to live right near you in the same community. While there's nothing wrong with that, there's nothing that requires the executor to be local either. When it comes down to it, you need to find someone you trust to do the job, who has the ability, the skills to do it, and the capability, the capacity to do it if called upon. Let's address guardians for minor-aged children. Now, the guardian is someone who would be responsible for raising your minor-aged children if neither parent survives. Obviously, this is an important role. Think about people who have a relationship with your child or children now, and whose parenting style, discipline style, their personal values, religious faith, and all those other personal qualities would be a good fit, would mesh well together with you and your family. Don't focus on that person's financial condition, their financial situation. Hopefully, you've done good planning and you're going to leave behind financial assets, maybe through life insurance, that will help raise and care for your children into their adulthood years. Choosing guardians carefully also requires you to address this question if you're looking at choosing a couple to serve as guardian. What happens if that couple is no longer a couple, or if they can't serve together because of a disability, because of death, or because of a divorce? Can one of them still serve individually? Is it a situation where only one of them would be someone that you would want to serve in an individual capacity? When thinking through naming guardians, you want to be sure to address that, and that your wishes are well documented in your will. Now finally, let me speak about choosing a trustee for your will. Generally, when we talk about this, we're referring to a person who manages assets in trust that are left behind for your children because they are minors or because they're very young adults and you don't want them to receive those assets just yet. If someone can't manage their own money, that's probably not a good choice for you to make to be the trustee of your will. Again, I also recommend that you select somebody different than the guardian to serve the role of the trustee. That's because it builds in some accountability. It can create some checks and balances, and you now have multiple eyes looking after your children and at each other for the fiduciaries to make sure that they're doing a good job and that they're taking care of your children. And that increased or enhanced accountability, in my view, is a very good thing. So choosing executors, guardians, and trustees, that's a very important step in getting your estate plan together to make sure that you've protected yourself and your family and that your wishes can be followed. But be sure that you don't get so bogged down in this decision that it keeps you from getting your planning done. That leaves your family at risk. Work with an experienced attorney who can make the process easier and help you identify how to best make these decisions and get your planning documented and done. Now, if you'd like some free information on estate planning here in Georgia, we're happy to send that to you. Call our office or email us through our website and request your free guide to estate planning in Georgia. We'll send that out right away, no strings attached. Or if you're ready to work with someone now to make sure that you and your family are protected and your wishes are documented, give us a call today. We'd be happy to talk with you and see if we could be of help. You can reach us at 678-344-5342, and you can visit us online at thebeckfirm.com. Thanks.